story. Would you like to stop paying rent, not move out, and demand your landlord pay you a massive relocation fee? That's just what's happening in Los Angeles with Airbnb renter Elizabeth Hirschhorn. She's been refusing to leave someone's property for more than a year, and some provisions in state law make it appear she can't be evicted. Michelle Trigger of Trigger Law with me now live to walk us through the potential legal pitfalls an Airbnb host might face so you can avoid them. Michelle, good morning to you.
Good morning.
This scenario sounds like it's just made up, a Hollywood plot, but it is very real, and it starts with an ADU, an accessory dwelling unit. What do I need to think about legally if I want to rent my ADU out through something like Airbnb?
So this has become a pretty timely topic because more people we see these days are renting out, whether it's a room or, as you mentioned, an ADU, whether it be a guest house or separate living quarters on their property, perhaps one of their vacation homes. But they start renting these platforms such as Airbnb, VRBO, and unfortunately, we are seeing the most extreme situation that you can imagine, which is when a guest has made themselves into a tenant on this gentleman's property. And so this story, if nothing else, could be a fair warning to anyone thinking about doing these types of rental situations.
The so-called tenant from hell in Los Angeles originally agreed to pay $105 a night for 6 months to owner Sasha Jovanovic, and then decided she didn't want to leave, claiming now that the place wasn't ever correctly certified for rent, so she therefore doesn't owe rent. This has to do with the missing certificate of occupancy.
That's correct. So it's county specific, but particularly in Los Angeles County, in order to use a unit as a rental, you have to achieve one of these certificates. Basically, it's a certificate that makes sure that a rental unit is going to be compliant with various business codes, various code sections that would just make sure habitability is existing. So if somebody comes over to your home and they stay as a guest, surely you don't need any type of certificate for that to occur. Unfortunately, when you start turning it into a rental and securing tenants, that's when the certificate is required. And so in this situation, she began as a guest, as most Airbnb guests are. And then because of the length of time in this situation, a 6-month period existed, she essentially did some research, figured out that her rental did not have this type of certificate. And because she was now a tenant as opposed to a guest, she brought that up and indicated that her rent that she had paid should be paid back to her because it was an illegal unit.
The certificates we were just talking about required by California cities for remodels and improvements, new commercial spaces like we were referencing. Make sure these spaces are now safe for the public. She's also claiming that the shower on site was built without a permit, which is why it leaked and then created mold. And that too gives her some kind of cover against eviction, kind of voiding the contract they made.
Potentially. So permits are usually required because we want to make sure whenever the work is done, particularly in a place where someone is going to live, that it's done in a safe manner. So when somebody installs a pool, for example, we need to make sure that a permit exists. When you have a rental unit and you want to install a shower or really a bathroom in general, we require that a permit be achieved to make sure that the work is done properly to avoid things such as mold. So Ms. Hirschhorn's theory in this case, which is interesting, is that because the shower was not done with a permit, it was not done properly, created mold, which is exactly why you get a certificate to avoid these types of situations, and that she should not be responsible for the rent she's been paying because she was paying for what she believed, or she says she believed, was sort of a valid, legally permitted unit.
Okay, now, we've heard, it's been reported, that she's actually pulled something like this before in the Bay Area and Oakland in a $2.6 million home. That fight was worked out just 2 months before she picked what seems to be her next target in Los Angeles. So maybe people need to do a little background checking. Is it that amount that she's paid that's like giving her some legal basis for this massive relocation fee that she's asking for? Because she's asking for a $100,000 relocation fee on a dwelling she is not paying rent for right now.
That's correct. So she's asking for a $100,000 relocation fee. And where this stems from is that there is an ordinance in Los Angeles County called the Just Cause Ordinance. You can only evict someone with just cause. And when you do so, you actually have to give them an opportunity to cure it. One of the reasons you can do so is non-payment of rent. But again, you actually have to have a legal unit to be legally renting it. And even if you can successfully evict someone, this same ordinance requires you to provide relocation assistance. And so in this situation, she's saying, if you want to evict me for non-payment of rent on my illegal unit, which should be at no value whatsoever, you have to give me relocation assistance. Now, what a reasonable cost is something for litigation, because while you and I would probably agree that seems to be an outrageous number, we're also talking about Los Angeles County, and she has a history of living in, we'll say, very upscale residences. Right. And so that's probably where that price is coming from her perspective.
All righty, we're going to have to put a pin in it there, but this is evolving in the court, so I'm sure we'll chat about it again. Thank you so much.
Thank you.